The very important piece of news coming in. The centre has defended sedition law, and they've told the Supreme Court that there's no need to refer the matter to a larger constitutional bench. The top court will hear the matter on Tuesday. The centre also told the Supreme Court that previous Kedarnath verdict on sedition is binding. And for more on this, I'm joined by my colleague Meenakshi Bhanja on the broadcast. Meenakshi, thank you for joining us. It's a very significant position opted by the centre. And as you mentioned that in the last hearing as well, the Attorney General also said that sedition is a law which needs to stay. What more details can you share with us?
Well, absolutely, Arjuna. Very quickly, some backgrounder, like you correctly mentioned in the last hearing, we are talking about the Attorney General of India, Mr. K. Venugopal. He had said to the Supreme Court in no uncertain terms that the sedition law overall should be retained, but the Supreme Court should consider passing some guidelines to check its misuse. Now, what had happened was the articulated legal position of the central government was awaited by the Supreme Court on this particular matter. That response, by virtue of this affidavit, now has come by, where, like you rightly mentioned, the government of India is telling the Supreme Court that there is no need to refer or to have the earlier 1962 Kedarnath Singh judgment be relooked at by a superior bench composition of the Supreme Court. Now, what is this Kedarnath Singh case? It was a landmark judgment of 1962 by virtue of which the apex court had upheld the constitutional validity of sedition law. However, it attempted to restrict the scope of its misuse. The Supreme Court back then, by virtue of a 5-judge bench composition in the Kedarnath Singh case, had laid down certain guidelines which would go on to determine what offences fell within the ambit of sedition or not. The Supreme Court back then had clearly stated that unless accompanied by an incitement or call for violence, criticism of government cannot be labelled as sedition. So what will happen, Arjuna, Tuesday is this, that the government of India now is telling the Supreme Court that there is no reason to reconsider or have the Kedarnath Singh judgment relooked by a superior bench composition of the top court. This Kedarnath Singh judgment from 1962 was passed by a 5-judge bench composition. So for the present Supreme Court to even have a relook at the Kedarnath Singh judgment, a superior bench composition of no less than 7 to 9 justices would be required. So government does not favor relook or overturning of the Kedarnath Singh judgment, which clearly means the government is in favor of retaining the sedition law, something which we have seen earlier also, like we just mentioned, where the Attorney General for the Government of India has told the Supreme Court that sedition should be retained, but additional guidelines should be issued to check its misuse. So Tuesday, when the matter is slated to be taken up, this articulated legal response of the government will be taken into cognizance by the Supreme Court. There could be further debates and arguments surrounding this issue, but the position of the Government of India on retaining or not retaining sedition law has come out now clearly in the open. And Tuesday, the Supreme Court will consider whether or not to refer this question of retaining sedition in its present form in India, that question, whether that should be referred to a superior bench composition of no less than 7 to 9 justices or not.
All right. Thank you, Meenakshi, for these updates.